Good afternoon. Well, good afternoon, everyone. I now want to
Good afternoon, Governor.
recognize Counselor Ianella for prayer and pledge of allegiance.
Thank you very much. We seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decision with impartiality.
Thank you, Counselor.
I pledge allegiance to the flag
The United States of America,
to the
Republic
which stands one nation under God, indivisible, with liberty and justice for all.
all. Thank you. I'd now like to recognize Counselor Duff for a motion to record advice and consent for the financial warrant.
So move, Governor.
Second.
Motion's been seconded. All in favor? Any opposition? The ayes have it. I now recognize Counselor Kennedy for a motion to record advice and consent for the pending list of notaries public.
So move, Governor.
second.
Motion's been seconded. All in favor, say aye. The opposition? The ayes have it. I now recognize Counselor Duff for a motion to record advice and consent for the appointment of John C. Frazier to the position of Associate Justice of the Superior Court.
Excellent appointment. I so move. Thank you.
Second.
Seconded. Any discussion? I'd now like to ask the secretary to call the roll.
Counselor Jacobs,
Yes.
Counselor Ferrara,
Yes.
Counselor Devaney,
Yes.
Counselor Ianella,
Yes.
Counselor Duff,
Yes.
Counselor Kennedy.
Yes.
Counselor DePaula,
Yes.
The vote carries. I now recognize Counselor Devaney for a motion to record advice and consent for the appointment of Karen E. Goldenberg to the position of Associate Justice of the Superior Court. Counselor.
This is on the vote for,
I'll repeat it. This is for the
okay,
appointment of Karen E. Goldenberg.
I couldn't be happier with this nominee. She has the qualifications. She has the experience and what I look for, compassion. And I got a lot of calls, I got a lot of letters from people that I respect. And I'm very pleased that you presented her, and I'm very pleased to put her name and nomination here. So I make that motion.
Thank you, Counselor. Thank you. Any discussion? Hearing none, I'd now like to ask the secretary to call the roll.
Counselor Ferrara,
Yes.
Counselor Devaney,
Yes.
Counselor Ianella,
Yes.
Counselor Duff,
Yes.
Counselor Kennedy.
Yes.
Counselor DePaula,
Yes.
Counselor Jacobs.
Yes.
The vote carries. I now would like to recognize Counselor Kennedy for a motion to record advice and consent for the appointment of Matthew J. Nestor to the position of Associate Justice of the Superior Court.
So move, Governor.
Second.
Discussion?
Discussion? I recognize Counselor Devaney.
For people to know, first of all, I just want to say I've had an ear infection and the hearing is still not back, so please bear with me. The doctor said it will come back. But anyway, we all have got letters, we've got calls about the nominee. Now, let me tell the public what the process is that they don't know. When the governor nominates someone and for the court, that nominee for judgeship is required to fill out a questionnaire of the governor's council under pain of perjury. And they are required to return that completed questionnaire within 8 days before the hearing. The district counselor of that person sets the hearing date. So as always, I object to it when they put it up in a week because the district council set it up for a week after we got the name. It is impossible, can't go back to the future, for that nominee to have his completed questionnaire to us 8 days before his scheduled hearing, because he wasn't even nominated by the governor 8 days before the hearing. So I object to it all the time. And this is a prime example of why this tradition should stop. There are people who wanted to speak in opposition to this nominee. But they didn't know he was appointed. And they looked at the website to see who was going to have a hearing. And they saw that this nominee's name was up and his hearing was over. Now, we all believe in the right to speak. And on our agenda, we have an item to allow people to come to speak in opposition. These people have been closed off. And they have not had the ability to express their opposition. So I'm asking to delay this vote. A week won't matter. I don't believe that any group, elected people, would go forward without having these people have their day, so-called in court, to speak of their experience before this person, how they know him, and to talk in opposition. So I respect my counselors, and I'm asking if you respect me, that we have these people to come and express their opposition, and then with all the due information that this council needs to take that vote. And so I'm asking that we proceed with that and not take the vote today. It won't change anything. You've all been called, I guess, last night, and I feel this is the only right thing to do. And I'm going to say it again, please stop this practice, asking a nominee to have his questionnaire in when it's impossible in the dates. So that's it. I don't want to be redundant, but I say this from my heart and my head, because I believe that you're ready to stand up and oppose me. I know, Councilor Kennedy, but I'm saying, yes, we need people in the Superior Court, but this is about freedom of speech. This is about the people's right to know. And whatever you have to say, Councilor Kennedy, I appreciate it and I respect it, but this is wrong to keep on having these hearings when there's not ample time for people to know and not ample time for the nominee to do his due diligence in applying to that questionnaire. So let's do things right. I get up every time when someone puts it up in a week and no one supports me. I'm asking you, councilors, support the people that you represent. They deserve the right to know everything before we vote. A week won't matter. Thank you, Governor, for letting me have all this time.
Thank you,
There's
Councilor.
been a motion and a second. I see the question. Second.
Further discussion? Seeing no further discussion, I now ask the secretary to call the roll.
Councilor DeVini,
We're voting? Are we voting?
Moving ahead with the voting. There's further discussion.
For the people of the Commonwealth of Massachusetts, I will be abstaining because we have shut off people's right to speak, and that's not what we're here for. Thank you, Governor.
Thank you, Councilor.
Councilor Iannelli,
Yes.
Councilor Duff,
Yes.
Councilor Kennedy,
Yes.
Councilor DePaulo,
Yes.
Councilor Davis,
Yes.
Councilor Burr,
Yes.
The vote carries. I now recognize Councilor Jacobs for a motion to record advice and consent for the appointment of Deepika Shulka to the position of Associate Justice in the Superior Court.
It gives me great pleasure to make that motion. Thank you for this nominee.
Second.
Any discussion? Hearing none, I'd ask the secretary to call the roll.
Councilor Iannelli,
Yes.
Councilor Duff,
Yes.
Councilor Kennedy,
Yes.
Dr. DiPaolo,
Yes.
Dr. Jacobs,
Yes.
Dr. Ferrer,
Yes.
Dr. Devaney.
Yes.
Vote carries. Thanks, everyone. I believe our business is concluded.
Thank you, Governor.
Thank you.
Everybody's so quiet. I'm going to call this hearing to order. My name is Marilyn Petito Devaney, and I am honored to be presiding over this nominee, Julie Green, who is in my district. That's how it works. So welcome. I first want to introduce the councilors who are attending. Councilor Ianella,
Good afternoon, how are you?
Councilor Kennedy,
No.
Councilor DePaula, and Councilor Laura, and Councilor Ferrara.
Thank you. Good afternoon.
And before I start, I have some ground rules. And one of them is that I want all people to put cell phones away. And that includes all councilors. And this is a very special day. And it should be with respect. And so I'm asking the councilors, please put the cell phone away. And I'm asking that the councilors please remain till the end of this hearing in due respect to this nominee. So having said that, I'm going to ask anyone who wants to speak, including, and I'll include you, to take the oath, okay? If you stand. I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. Thank you very much. So I welcome you. And now I want you to introduce everyone in this room that has come to support you.
Thank you, Chair Devaney, for that opportunity. I am lucky to have a number of people here to support me today. Most importantly, my family, my mother, Mary Jean Green, my father, Ronald Green, and my youngest, Ashton Slama. I also have my dear friend, Lauren Bernard, and I am very fortunate to have a whole group of my colleagues here today from the Attorney General's office. Constantine, Aaron, Phoebe, Jen, Sulaikin, and then I have two who have agreed to come speak on my behalf today, Tim Casey and Dina Verasano.
And of course, we have someone sitting in the governor's chair. So first, I'm going to read the letter from the governor. Dear councilors, I am pleased to nominate Julie E. Green to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy. So having said that, the next part of our hearing is to have your witnesses speak. So I am going to call on your first witness, who is Timothy J. Casey, Chief Constitutional and Administrative Law Division, Government Bureau, Office of Attorney General, Andrea Campbell. That's a lot. Welcome.
Good afternoon, members of the Governor's Council. My name is Tim Casey, and I'm Chief of the Constitutional and Administrative Law Division at the Attorney General's Office, or the CAD Law Division, as we like to call ourselves. It is my privilege to be with you here today to say a few words in support of my friend and colleague, Julie Green, as her nomination to the Superior Court is before you. I've known Julie for 8 years, first as a fellow Line A AG in our division, then as her supervisor when I became chief of the division in 2019, and then as fellow managers in the division when she was promoted to managing attorney and later deputy chief of the division. Since joining the AG's office in 2016, Julie has worked on some of the biggest and most important cases in our division. To name just a few examples, she defended successfully our state assault weapons and large capacity magazine bans against the Second Amendment challenge in U.S. District Court. He has vigorously defended our state's paid family and medical leave law against a preemption challenge also in federal court. She worked with our then state solicitor and now SJC Justice Bessie Dewar in an original action filed in the U.S. Supreme Court by the state of New Hampshire against Massachusetts. challenging our Department of Revenue's rules for New Hampshire-based employees who worked remotely for employers located in Massachusetts during the pandemic. She successfully persuaded the Supreme Court to dismiss the case. Julie has also tried cases in Superior Court, and she has appeared there regularly in all manner of dispositive motions and pretrial proceedings. She has worked on complicated and important matters in our state superior and appellate courts, on matters that raise questions like whether and how our state sales tax law may be applied to internet-based vendors, or whether a state trooper accused of significant conduct must be reinstated, or the effect of a federal corruption conviction on a state law license to engage in lobbying. To name just a few examples. Having observed Julie's work on these cases and many others, and having had countless conversations with her, especially as fellow managers, I want you to know 3 things about Julie that will make her a great Superior Court judge. She is smart, she is tough, and she is kind. First, she is smart. I'm sure you've observed this yourselves in your conversations with her, and I know you're familiar with her background. But her entire academic and legal career is a testament to her intellect and her talents. She is a Fulbright scholar, a magna cum laude graduate of Harvard Law School, where she was editor of the Harvard Law Review, and a law clerk on the U.S. Court of Appeals for the Ninth Circuit. Since I became division chief, I always breathed a sigh of relief whenever I assigned a case to Julie, because I always knew that she would handle it with the utmost competence and excellence. Julie's intellect allows her to cut through dense legal thickets and complicated areas of law, and explain the issues to the judge, to opposing counsel, and to her clients in a way that is clear and accessible. Her legal writing is absolutely first rate, and I cannot wait to read the decisions that are issued by Justice Green. Second, she is tough. This one may be a little surprising because you might not know it when you first talk to her and observe her calm and serene demeanor. But listen to how she talks about a case and how best to get a just result. And you'll see that she is willing to work relentlessly toward putting her client in the best possible position. Similarly, as a judge, I know that she will work tirelessly to issue just decisions and render judgments that are fair, comprehensive, and just, because that is how she has approached being an advocate for her clients. In our division, we have a good mix of both appellate and trial court work. Although Julie is tremendous at handling appeals, I also have always wanted her in the room when I was advising a more junior AG about a complicated issue of trial practice, whether it was how to deal with difficult opposing counsel over a discovery dispute, or thinking through a complicated evidentiary issue, or how to conceptualize moving a case from the complaint to a summary judgment motion, or how to prepare a case for trial. I knew that Julie's instincts and experience, born of her toughness, would be invaluable in guiding our more junior AAGs through the often daunting process of preparing a case through the civil trial process. As a seasoned litigator, Julie has had to deal with more than her fair share of judges who subjected her to merciless deadlines who were imperious from the bench. And she worked at law firms where experienced female attorneys all too often were disrespected and their opinions disregarded. These experiences could have embittered Julie. They did not. Instead, Julie's toughness allowed her to weather these indignities, to commit in her own life and her own practice, not to do the same to others. This leads me to my third and final point about Julie. She is kind. She will be gracious and courteous to lawyers and litigants. She will treat every case like it is the most important one for the parties before her in the case. She will be kind and collegial to fellow judges, clerks, and court officers. She will be a good team player within the Superior Court, just as she has been at the Attorney General. And at a time when we all too often talk about lawyer well-being, but where judges sometimes don't fully understand the role they occasionally play in undermining lawyer well-being, Julie will do everything she can to foster this important priority by treating lawyers and parties with respect and being reasonable about deadlines and other aspects of trial practice that can sometimes negatively affect lawyer well-being. I know this because Julie has been ceaselessly kind as a colleague in our office. As a manager, she has always expressed concern about the lawyers and staff in our division and helped me to see when somebody maybe needed a little extra help or support, or just needed some positive feedback or an interesting new news to help lift their morale. Julie does this because she cares deeply about people. I have no doubt she will care deeply for the people she works with and the people who appear in her courtroom every day. So, while it will be a tremendous loss for our office and our division to have Julie leave us, I know that our loss will be the Superior Courts, the bars, and the Commonwealth's gain. I therefore wholeheartedly support and endorse her nomination to the Superior Court. Thank you for your time today.
Thank you very much. Has anybody any questions? Counselor Inella?
Just one quick one, I may not have read this correctly. Did you say that she worked at law firms that disrespected women? Oh, that's what you said.
Yes, yes.
Well, I look at her resume here. She's only worked at least what I look at, 3 different law firms. So it's. And 2 of them were local. You don't have to name it if you don't, it's, we can, 1, 2, or 3. If you want to name that law firm? You don't have to.
No, Counselor, I don't want to,
Because you brought it up, and then, you know, I usually, to be totally honest with you. I don't know if anyone's ever sat in that seat that's actually made that allegation that. Law firms that someone worked at, disrespect women. I'm not saying it doesn't happen, but I've never heard anyone in your seat where you're sitting say that, so I was a little caught off.
Counselor, I just mean to speak in a kind of general sense. I'm not making specific accusations against specific firms or specific lawyers. I just meant to convey the general point that as a very experienced and talented litigator, Julie Green has dealt with the rough and tumble of being a litigator, both at a firm and in the courtroom, dealing with difficult opposing counsel. And I think she has handled those difficulties with grace and aplomb.
I won't press you, but you did say that she's worked at law firms, and I look at 3 that have disrespected women, and there's only 3 law firms here, so it's one of the 3. But I'll leave it at that, and I appreciate your testimony. Thank you.
Thank you. Anyone else? Oh, Counselor Ferrari.
Thank you for coming today. She has some great support, including Justice Dewar from JC. One thing that caught my attention was she handled the First Amendment challenge to disclosure requirements of the Commonwealth's campaign finance law, which we are all familiar with being on the council. So I just wondered, did you participate in that challenge, and what was it about?
I did not, and it was before my time as chief of the division, but I know a little about the case from being a colleague and a fellow line AAG with Julie, and I know that she litigated the case again in a way that was tough but fair. She put the other side through its paces in terms of discovery, and ultimately they decided that they would rather voluntarily dismiss the case than continue to litigate once they saw that Julie was going to vigorously and zealously litigate the case. So I think that is a good example of how Julie is excellent at dealing with legal doctrine and legal issues, but also is good at thinking like a trial lawyer and thinking about how to handle cases in ways that are firm but fair.
Thank you.
Thank you. Counselor Kennedy.
Sounds like, and I agree with you. She's very, very bright. I picked that up talking to her on the phone quite a bit. I have one little concern that maybe you could address. It's not a little, very, very limited criminal experience. I think it's just one rotation through the BMC when she was a new lawyer, it looks like. Which, you know, you get some out of that. A lot of people do. It was a young woman that I remember doing a rotation in the Somerville court 20 years ago, and you might have heard her name was Maura Healy. But Superior Court, she's gonna be handling some pretty serious criminal issues. How do you think she's gonna be able to catch up with that? And that takes a lot to figure that out, especially when it comes to sentencing. To me, sentencing is an art. You have to be able to figure out what the appropriate sentence is to give each individual case. And that's what comes with experience. What do you think of that?
Counselor, I think that what I know about Julie is that she's extremely quick study. And she has dealt with some of the most, yes, our practice is primarily civil in the Government Bureau of the AG's office.
And in the firm she was at, too. So
some of our
Commonwealth does some criminal work too, but I think she was in the civil end of it from what I can see.
in our office, though, we do work on a lot of cases that involve the civil or collateral consequences of criminal cases, indictments, convictions, and the like. So she is not completely unfamiliar with criminal practice, criminal law. The effect of a licensing case when the person has had a conviction expunged, things like that. So she has worked on criminal issues. What I know about Julie is that she will seek out the guidance of experienced Superior Court judges. As you pointed out, sentencing is something that is just an art. It requires experience. It requires sensitivity. I think and I expect that she will seek out experienced Superior Court judges and ask them for their. I've done a little as an ADA in district court, and again, working at the AG's office on cases involving the right to counsel in criminal cases and similar issues.
And by the way, I don't disagree with your statement that some women in the legal profession generally are discriminated against. I think that still goes on. They certainly, I've seen it with a lot of women I know in the law, including a family member. I don't disagree with you, and I talked to her about that briefly. Thank you.
Thank you. Anyone else? Your testimony was very thoughtful, and we appreciate that because the council looks to the witness to learn about this nominee. I'd like to ask you, because a lot of people don't know, I don't know. Tell me, you're the Chief of Constitutional and Administrative Law Division. Tell me, what kind of interaction did you have with this nominee? Was it day-to-day? And tell us specifics.
It was day-to-day, especially over the last 3 or 4 years when we were fellow managers of the division. So we talked virtually on a daily basis about cases, about other lawyers and staff in the division. She was very concerned about people's well-being. She wanted to make sure people were getting good and interesting cases, that we distributed the cases equitably and fairly. Julie and I were partners in assigning all of the cases in the division. We have a little over 20 lawyers within our division, but we have between 1,000 and 1,200 open cases at any given time. So triaging the cases that come in and assigning them to the lawyers in our division is very important. Julie took that role very seriously. I will also say that I have observed Julie in court regularly in her own cases, both when we were line AGs together and when I became division chief. I would say I've observed her in court perhaps 10 times or so. She is outstanding in court. Excellent on her feet, a quick thinker, able to make a point forcefully and effectively, but diplomatically. She is someone that junior lawyers could and should watch to see how to do it in court.
Thank you. Well, your testimony means a lot to us, and I appreciate you coming today. Thank you.
Thank you.
The next witness is Dina Barasano. How did I do with that? If I don't get the Italian names right, that's shame on me.
That was perfect. Thank you. Good afternoon. My name is Dina Barasano, and I am a paralegal and the administrative assistant for the Constitutional Administrative Law Division of the Office of the Attorney General. And I don't say that all when I answer the phone. It's just too long. Since Julie Green joined the Attorney General's office, I have worked as her assistant and paralegal. Unlike other colleagues, Julie never forgot that I support several other attorneys and that I held additional positions involving clerk work in my own docket of administrative appeals for many years. And I also juggle my ongoing responsibilities as our division AA or administrative assistant. Julie always asked if I was available rather than order me to work on a new project. She also listened to me as someone who had worked in the office for many years, and when I brought to her attention errors in procedure and other legal areas by our clients about working people, specifically in 2 legal actions involving the livelihood of working people, childcare worker and a bus driver, she did not dismiss my concerns. Julie listened to what I had to say, and she passed those concerns both on to our clients and other division attorneys when one of the cases was transferred, resulting in these clients taking another review of the validity of what they had wrongly determined. No other AAG or Assistant Attorney General has taken my paralegal input about such matters into such consideration and action. Julie also gave me my first and only opportunity as a paralegal to work on a U.S. Supreme Court brief, reading through it and formatting the tables. It was an honor, and I will always appreciate her having the faith in me that all other colleagues did not have, and my being able to execute that supporting role in a very important and complicated tax case. On personal matters, I will always appreciate her understanding and caring when my mother had a mastectomy in a second-round fight against breast cancer and during my own lumpectomy. During the COVID lockdown, despite my vision issues and adjusting to the new technology of remote work and also the caretaking of my mother, Julie always appreciated and supported my professional efforts, not just for herself, but for the entire division and for other attorneys in the Attorney General's office. When my mother's cancer returned and she entered hospice at home and HR granted me permission to be remote for that time, my attorneys were sympathetic, but Julie was the only attorney on a lone day off after closing several complicated matters to offer to physically help me with caretaking. An offer of support she was gracious about me having to decline because I explained how much I appreciated it as an only child and caregiver, but she also understood about my mother's issues and anxiety. Her offer was kind and generous and from the heart. When Julie became our managing attorney, co-managing attorney and deputy division chief, we had several frank and honest conversations about the difficulty of our division's overall restructuring and the hiring of additional attorneys, which is going to put a large burden on the 3 administrative paralegals that I supervise. I felt safe to confide in her about many related issues without fear. Personally and professionally, I believe she served the Commonwealth over the years at the highest level while also managing the duties of a spouse and mother, and she will continue to try to bring those positive qualities and efforts to her new role in the judiciary. Thank you.
Thank you. Are there any councils who have a question? Councilor Jacobs.
First, just a comment, just thank you for sharing. Your testimony is really powerful and heartfelt and moving. So thank you for sharing that. Your mom is okay right now, Mom?
I'm sorry,
Is your mom doing okay now?
my mom passed.
Oh, I'm so sorry. I missed that part.
Thank
It
you.
was very distracting in the room, but I'm very sorry to hear that. It really is moving to hear you share the relationship that you've had and the kind of person that Attorney Green's been in your life. I'm curious if you've ever seen Attorney Green lose her patience or under stress, just your experience of how that plays out in your perception.
Well, I think we all have our moments, it's a stressful environment and, when it's a public law office, we have to do more with less. But I think that, she came from a culture of a law firm, which is different, but she was able to make that adjustment. And I think, again, I appreciated, the learning curve for her, I think was okay. I think she delved in and she understood when I told her we just couldn't do certain things, we just didn't have that capacity. And I think that she always showed grace under pressure, whether it was a case that was just, a small administrative appeal or she was part of a larger team. I think that, I think she showed patience to pull the support staff, our mailroom, me, myself, and also the other attorneys that, we work as a team.
Appreciate that. Thank you so much.
Thank you.
Anyone else? I want to tell you that you really are the most important person to talk to the council because you see this nominee on a regular basis, her highs, her lows when she's under stress and everything. So is there anything probably that, we all have different things that happen in our lives that you remember how she reached out to show me her compassion? Can you talk about any of that?
Well, I think I did speak to it a bit in my statement, but I have had caretaking in my life, as an only child, I didn't have a lot of options. So I think she understood that, very quickly. We had a professional relationship, but personally, I've always appreciated that she had that kindness, and I think she always gave me the benefit of the doubt, and I think that, again, I always have said I tried to multitask and also do my work well. But when I came to her and said, I don't think I can do this, she was always very fair, about what was happening and maybe getting an extension of time. She was always very open-minded and very generous about that. So I think that she took those extenuating circumstances into consideration, not just from myself, but maybe from other counsel as well. If there were, maybe I was the one that got the call about an extension. I can't think of a specific, other than, again, my mom's illness over the years, and again, the time around, it was just a very intense time for me, as I had both my parents at the hospital at the same time. And it's kind of like the only child nightmare, running between buildings at MGH. You don't want that for anyone. So.
What would you think is the most outstanding quality that she brings to the court?
I just think her sense of fairness, when it went the eye of, again, with procedure, and again, we're representing clients, a very large group of, state agencies. And when I brought to her attention errors in the record, errors about perhaps an investigation, witnesses not being included, she didn't dismiss me for the sake of, it's hard to stand up to a client. It's hard to take another look. We're all very busy. She took those concerns, as I wrote, and it was a valid, outcome. The agency realized in both instances and took another look. And those people, that was their job. That was their livelihood. And she took that into under advisement, if you will. And it was very, again, a genuine concern, and she didn't dismiss it. And it was a wonderful follow through as well. Even when one of the cases was transferred, she made sure she conveyed that to the next AHE that was taking over, and we saw a result. And I think that's a quality that she'll bring, that attention to detail with concern, as well as the legal procedure that's also involved.
So you must have mixed emotions congratulating her, and yet you hate to see her go.
It's true. We'll miss her very much.
Yeah, right. Well, I do want to say that I did give you your due, that you are an administrative assistant and paralegal, constitutional and administrative law division in the Government Bureau of the Office of the Attorney General, Andrea Campbell. So I neglected to say that. So I thank you. Your testimony means a lot to us. So that will be the last of our witnesses. And so now I welcome anyone. If you'd like to say a few words, we welcome you to come forward. Hearing none, is there anyone in opposition? Hearing no one in opposition, now is your time to tell us about yourself. Thank you.
Chair Devaney, governors, counselors, thank you for the opportunity to appear before you and for taking the time to talk with me in advance of this hearing. I appreciate the vital role that you play in the selection process and how hard you work to fulfill that responsibility. And I am honored and humbled by the confidence that Governor Healy and Lieutenant Governor Driscoll have shown in me through this nomination. Thank you also to Valerie McCarthy for your kindness in helping me navigate this process. And thank you as well to Tim Casey and Dina Barisano. I am honored that you were willing to speak on my behalf today. And thank you also to Paige Scott Reed and Derek Kesselheim. And I'd also like to thank the members of the JNC for their service in reviewing judicial applications like mine. And thank you also to Chief Justice Ricciuti for being here today, and so many of my dear colleagues who have come out in support. I think the best way to tell you about who I am is to tell you about other people. Most importantly, my parents, Ronald and Mary Jean Grady. I come from a family of teachers. Both my parents and my husband, Yarek's parents, are teachers. My parents, Ronald and Mary Jean Green, were professors at Dartmouth College, And so I was lucky enough to grow up in the nearby small town of Norwich, Vermont. My father's family came to this country fleeing persecution in Eastern Europe, and he was the first person in his family to go to college, eventually becoming a professor of ethics. When I was growing up, over the dinner table, he would tell us about the ethical dilemmas of the day, and he taught me the importance of treating each person with respect for their individual human dignity. My mother's family, too, deeply valued education. She remembers her grandfather from a family of coal miners outside Scranton, Pennsylvania, who didn't have much education himself, but he was always giving her books and urging her to read. His encouragement bore fruit when she became a professor of French literature. Her efforts led to an early experience that has shaped my life. When I was in first grade, my mother moved the family to France for a year and fearlessly enrolled me in the local public school, even though I did not speak a word of French. But when I arrived the first day, mute and terrified, the other kids welcomed me, and they patiently talked to me and kept talking to me until one day I started talking back. This childhood experience of being a frightened outsider taught me an early lesson about tolerance and understanding for differences. The love of language that I got from my mother propelled me to another experience that changed my life. After college, I went to Prague for a year to teach English and learn Czech, and that is where I met my husband, Jarek. Jarek eventually left behind his family and friends to come to this country to marry me, for which I am grateful to him every day. He worked hard to build a new life in this country as a physician at Boston Medical Center, where he serves patients representing the full diversity of this city. Marrying Jarek, I have been welcomed into a large extended family who we visit every summer in the Czech Republic, which is where Jarek and our older son Julian are right now. Ashton, my artist, just graduated from high school and is here today. I started out talking about the value of education, but the most important education I have received was from my clients themselves. I believe that understanding diverse perspectives is important to being a good judge and a good human being. I have been fortunate in my civil practice to learn from a wide variety of clients. I have represented plaintiffs and defendants alike. I have been a government lawyer, but I have also brought cases challenging government action. I have defended the constitutionality of state statutes, but I have also pursued claims to right individual wrongs. And I learned something about the experience of criminal defendants when I volunteered for a pro bono program doing criminal defense work in Boston Municipal Court. I also believe that listening to diverse perspectives, that to understand diverse perspectives, you need to be a good listener. At the law firm of Todd and Weld, I learned from some great trial lawyers that the key to winning a case is painstaking preparation, asking every question and listening carefully to the answers so you can educate the court about your client's whole situation. So for example, when I brought sex discrimination or sexual harassment claims, I had to pursue every lead to uncover the often hidden ways that discrimination can work to deny opportunity. When I took on the case of an incarcerated man seeking better dental care in prison, I spent time at MCI Norfolk and Sousa Baranowski speaking with inmates about the care they had received. These and other experiences have informed my concern for access to justice. When I was at Legal Services helping tenants in eviction cases, for every client we could serve, we had to turn two away. I have seen firsthand how hard it is to navigate the confusing world of courts and government agencies without a lawyer. I also believe that there is more to doing justice than just deciding cases. A clerk in housing court in New York City taught me an important lesson that I still carry with me. At the start of each session, she would call the list of eviction cases, sometimes dozens at a time, but she always took a moment to read each person individually and make sure she was pronouncing their name right. It was a small thing, but it went a long way to set a tone of respect. Joining the office of the Attorney General 8 years ago, has given me an opportunity to use all that I have learned to give back to the people of the Commonwealth. My years in public service have been some of the most meaningful of mine. I have had the privilege to defend state laws protecting our health, safety, and welfare, like our law banning assault weapons. And I've come to appreciate how lucky we are in the Commonwealth to have so many dedicated public servants working every day to protect children, to help keep our elections clean, and to apply our tax laws fairly. This same desire to give back through public service led me to apply for the bench. Through my husband, Yadek, who grew up behind the Iron Curtain, I know something about what it means to live in a society that is not governed by principles of fairness and respect for individuals. I've seen how injustice at the core seeps outward to affect every aspect of civil society. And so I do not take our system of justice for granted. What sustains it is the hard work, day in and day out, of judges who listen carefully and apply the law fairly, and court staff who treat litigants with dignity. It would be the greatest honor of my life to be able to contribute my energy and experience, and I hope a little wisdom, to that great project. Thank you, counselors, for your time, and I welcome your questions.
Thank you very much. Now I'm going to ask the councils if they have any questions. Councilor Ainello.
Not many. First of all, I was impressed with the witnesses. They did a great job. Councilor Kennedy, I believe, asked Attorney Casey about your criminal experience. Obviously, you don't have a lot of criminal experience. To me, and I don't do any criminal work, but I think it's very important for any judge, whether it's the district court or the superior court, to have some type of knowledge or understanding of mental health issues and addiction. So let's be fair. Most of the people who get arrested somehow, some way, drugs are involved. You have a B&E, you break an entry because you need money for drugs. What, if any, understanding do you have of mental health issues and addiction?
Thank you, Councilor Ianella, for raising that important topic. That's a very important concern, especially in criminal law, but also in civil law. Mental health and substance abuse are topics that are near to my heart and that I believe judges should take very seriously when they're considering criminal defendants and also civil litigants in front of them. I have represented clients for whom substance abuse has had a huge impact on their lives, and I've seen what it can do to the best of people. It is something that I have experienced firsthand in my own family, and we have been extremely lucky in my family to have had the support of wonderful special education professionals at in the public schools, people whose hard work has really changed our lives. So that's really an issue that I think we're learning more and more about. The science on those issues and how to treat them is developing. And it's something that as a judge, if you were to confirm me, I would take very seriously in considering cases before me.
Thank you. I don't have any other questions. I mean, you have an outstanding educational background, no question. Your work history is impressive. And when your name comes before the council either next week or the week after, I'll be more than happy to support you.
Thank you, Councilor Ianella.
Thank you, Councilor. I just want to interject on a personal note. I had an ear infection. It's not contagious, but I still haven't got full hearing. My doctor said it's going to be, so I'm asking people to really talk a little louder and into, for me. Thank you. I appreciate that. Okay, how about you, Councilor Kennedy? Do you have any questions?
I want to touch on that criminal question and sentencing. How are you going to handle that? I mean, I've been doing criminal work for 40 years. And I really believe that sentencing is an art that you'll learn as you practice as a lawyer, and judges eventually will learn how to do it. what are you gonna do to get up to speed on, criminal sentencing? Because you're gonna do a lot of serious criminal cases, everything from murders to rapes to kidnappings to armed robberies to et cetera. How are you gonna figure that out?
Thank you, Counselor. I really appreciate your giving me the chance to address that. That is a very fair concern, and I know I come here without the sort of experience that you have. I think, my appreciation for how important that is something, was what led me to volunteer for the pro bono criminal defense program. And I had an opportunity over 6 months to represent defendants in Boston Municipal Court. And so I learned something that it will give me some foundation going forward. But I agree that it is an area in which I really need to educate myself. And I have been working hard to start educating myself. And it's something that I am deeply committed to continuing. I have been speaking to Superior Court judges, especially judges who, like me, come from more of a civil practice background, to learn how they did it and how they put themselves in a position to
Some of them haven't figured it out yet. Well, they've been on a long time, but that's a different issue.
Well, what I've been doing to educate myself, I have been reading the Superior Court best practices. I have been studying the sentencing guidelines. I have read,
My view of the sentencing guidelines, by the way, is they should throw them out. I don't think you should ever look at those.
I appreciate that.
I think you have to sentence people based on the person that's in front of you and the facts and circumstances of the case. And sentencing guidelines, as we saw in the federal system, were a total failure, and they tended to cause sentences to go up over time. People doing more time. I'm not a fan of those at all.
I appreciate that. And I agree with you that Superior Court judges should look at the whole person in front of them, that they should take into account not merely the crime and the criminal history, but also all of the circumstances of the criminal.
So why are you looking at sentencing guidelines?
The sentencing guidelines, as I understand it, do have guidance about how to use those factors, but I've also looked at the Superior Court best practices, and I think those provide a lot of good guidance from Superior Court judges, including the importance of getting as much information as you can before sentencing a defendant to things like age and family background, mental health status, history of trauma, history of substance abuse. Those are all factors recommended in the sentencing best practices, and they're things that I would take seriously into account.
My experience is with new judges, both in Superior Court and District Court, when they come from a civil background. I do a lot of civil work too. I do a lot of criminal law, but is that they tend to, because they tend to be unsure of themselves when it comes to sentencing or bail or 58A hearings, they tend to default to the prosecutor because it's a safe way to go. In other words, a prosecutor is asking for 10,000 cash bail, defense lawyers ask for personal recognizance. They go with the 10,000 because they don't know any better. You know what I mean? They tend to default that because it's safer. Well, and same thing with sentencing. The prosecutor might ask for a 5 to 7. I might be standing there asking for probation. New judges that haven't done criminal work tend to default to the prosecutor, especially when it comes to bail issues in 58As. How are you going to handle that? What are you going to do?
I appreciate you raising that. As a judge, I would never default to any side. I would always listen carefully to both sides. I have been on both sides myself in throughout my career. I would endeavor to listen very hard to what both sides were saying to me, to study carefully all of the facts that they present, and to make up my own mind based on what the information before me.
How long was that trip you took?
It was
Got back this week, right?
I just got back 2.5 weeks,
Just the cruising in the Baltics?
10 days in the Baltics with my family. It was a trip with my 3 generations of my family.
Sounds like a dream trip.
It was wonderful.
Must have been pretty tense getting nominated while you were there. That call.
I think my parents didn't appreciate the dinners that I missed, but
Yeah. Well, they got
We're lucky to-
get on a plane to come home, huh? I think I think you're very well qualified. Yeah, clearly, you've had a very solid background, but I'm a Todd and Well fan. My daughter was there for about 10 years. I know a lot of the folks there. Some from just that being at that firm, and others that like Mindy Thompson and Dave Meyer from being prosecutors. So I've known a lot, Max Stern, the whole crew. But so you have a great background, and I'll be voting for you next week.
thank you, Counselor.
Thank you, Counselor Kennedy. Counselor DePaul.
Thank you, Counselor. Good afternoon.
Good afternoon.
Talking about sentencing, as Counselor Kennedy was, are there any areas as you're learning or exploring more on this issue? Are there any particular areas of concern that you hone in on around sentencing in the Commonwealth?
I have just been trying to educate myself across the board about all aspects of sentencing.
Okay, well, let's talk about racial disparities. So what's your understanding of, I guess, the quickly becoming dated Gantz report? What's happened since? Do you have concerns about what you read if you're familiar with that study?
I have studied the Gantz report, and I think we should all have concerns about what that report revealed. It revealed some very concerning racial disparities in various aspects. Sentencing was a major aspect. Racial disparities that it could not attribute to any other factors that might explain them. And it was very troubling when it revealed. I think one of the most significant takeaways from that study is it alerted us to how much we don't know still, and how much work there is still to be done in gathering data and in continuing to make improvements in how we do things. It also led me to look carefully at the best practices for avoiding racial bias in sentencing. And I take very seriously the recommendations of the best practices report, including things, and this has been echoed to me by Superior Court judges who do this as well, things like making careful written notes of your sentencing, of your thinking when you decide on a sentence, and then tracking your own sentences across cases so that you can be quick to pick up on any evidence of bias.
I appreciate that. And so entering Superior Court, you're in a unique position because that report indicated that all the sentencing disparities were happening in Superior Court. The charging phase is of course important. We have people of color landing in Superior versus District twice as likely when there's concurrent jurisdiction, obviously exposing them to additional or more stringent sentencing. Weapons and drugs were the two big categories. And so let's think about weapons in particular. Why do you think over the time period study, based on the info available, and I agree with the inference I take from you that we need more data to be more certain about things. Why do you think weapons are where we were locking Black and brown people up for 145 days longer than similarly situated white defendants?
I appreciate your raising that. That is a very important question. And I know that the report pointed out that charging was potentially a big source of the racial disparities that it was seeing. I am not familiar enough with prosecutorial decisions to understand why that might be happening. And so I agree with you that more data is necessary, but it's certainly something that I think we should take a hard look at and work hard to understand better.
Okay. Another issue in sentencing these days is the progeny of Diachenko and most recently Mattis and brain science. I'm wondering what's your perspective on that? You indicated in your statement, or maybe in one of the questions, that Obviously, our knowledge and understanding is developing. At the same time, I'd assert, based on my knowledge, that it is of course developing, but the courts are understandably and judiciously so a little behind where the science is. And that that's implied in some of the decisions where it notes that the science goes further than what the court in the Mattis decision, for example, is specifically looking at in that instance. What's your perspective on how brain science is impacting the way we think about sentencing? Or what's your perspective on how you think, based on where the decisions are, it's going?
I'm glad you raised that. The subject of emerging adults is a mother of two emerging adults. That's a subject that's near and dear to my heart. I have studied the Mattis decision and Diachenko, and I understand that there have been real advances in the science that help us to understand what's going on with that age group in terms of increased risk-taking and vulnerability to peer pressure, inability to plan in the same way, but also capacity for change, which I think is very important. I think I really applaud the efforts to dig into that science and bring it into the courts. And I think, I would endeavor to apply Mattis. Diachenko would be juveniles, but in Superior Court, I would endeavor to apply Mattis faithfully and to take seriously the issues of age and its effect on the brain as they might come before me.
It's my understanding, talking to folks in the defense bar, that this is something we're thinking about. And where else are there places where we might rethink the way we're doing sentencing? This is why I asked this question. I have one more line of questioning. You mentioned in your statement and in your application representing an individual who is seeking dental care in a DOC facility. Is that right?
Yes.
So it was a few years ago now, just like the Gantz report, when the Trump Department of Justice issued a statement indicating that they were concerned about constitutional right violations of our inmates in DOC facilities. It was mostly around mental health, access to mental health. I'm wondering, are you familiar with the status of things at that point? And I'm also wondering, are you aware of any improvements that have happened? I know that, and I'm curious in your role in the AG's office, if you've ever encountered constitutional issues around that.
That's mental health in the prisons is an extremely important issue. I didn't have direct involvement because I was focused more on physical care when I was there. It is something, it's an issue that has come across our desks in the AG's office. I have not myself worked directly on any of those cases, but I know that we are very concerned about the situation of providing mental health care and properly treating people who are in UC facilities. It's, there's nothing more important than ensuring that people who are suffering from mental health conditions do receive the proper treatment. And I think that's essential if we're going to effectively rehabilitate defendants as is, our goal when we're sentencing. So it's something that I would be, very supportive of and concerned about.
I know people on the ground in corrections have super difficult jobs, and I know no one's looking to do wrong by anyone. And I know it's a resource issue as well, but so to your knowledge, I'm inferring are you aware of what's been done since then? Have resources been allocated there? Is it a matter of reconfiguring things? And maybe you don't have direct knowledge, I'm just asking.
No, it's something I'd have to look into more. I would hesitate to give you an answer without really looking into it.
Okay. Thank you. I'm very impressed with your credentials. I appreciate your time this afternoon.
Thank you, Counselor.
Thank you, Counselor. Thank you, Counselor.
Thank you, Counselor. Counselor Jacobs.
Thank you. Well, it's good to see you. We had a really good conversation. You came out and I appreciate you taking the time to come out Western Mass and sit down with me, and we covered a lot of ground together. Rather than retread what we've already discussed, I wanted to delve in on some things that maybe we didn't. remind me though first, the prior questions sort of just trigger a thought that I honestly can't remember if we talked about it or not, but I know when you were advocating for dental hygiene assistance that you did visit Norfolk. I'm not sure other, I'm just curious, have you visited prisons recently, or is this more of a?
I have not been back in the facilities since that time. But at the time I was working, it was more than one case. So I had one client in MCI Norfolk and another in Sousa Baranowski. And I did have the chance to be back and forth in those facilities a number of times. I would have to probably like 2012, but I don't want to, don't hold me to the date.
Fair enough.
It feels like it's roughly 10 years ago. So, you know, I'm sure many things have changed, but I really had a chance to spend some time in those facilities as part of those cases.
I frequently advocate and want to say to you as well, I think it's a great idea for especially with limited, those two facilities only, but also how much time has passed since. If you are able to carve out time, I really do think it's worthwhile to visit the facilities, and even ones you've been to back over a decade ago, again, things have changed and continue to change rapidly. So what was doesn't necessarily reflect what is. So I'll just leave that with you as a thought that just, you know, I'd love for you to have that experience going into Superior Court where your sentencing, I think should be informed by the facilities that, you know, and the conditions as they are today. We didn't get to talk to it about it, but I wanted to hear from you about your thoughts related to in your application you talk about how important it is to be a mentor to underrepresented, marginalized members of communities where marginalization and lack of representation exist. Both you're talking about it in the sense of from a professional standpoint to encourage longevity of careers, people stay with the career when that outreach happens. I'd love to hear you talk about that specifically, and then kind of as a corollary, how you believe your values, your beliefs will reflect from the bench in relation to underserved and marginalized communities.
I appreciate your asking that. Mentoring is a subject that's near and dear to my heart. I speak really from personal experience. I come from a family where I did not know any lawyers. I didn't know very much about lawyering when I started, and I have benefited so much from the encouragement and the support of senior lawyers who took me under their wing and taught me and mentored me. And they inspired me and encouraged me to do things that I would not have done and I would not have believed I could do without their encouragement. And in fact, I am here today before you because I was encouraged 10 years ago by one of my dear mentors, Lisa Arrowwood, to apply to the bench. And I have, it's really been my dream, but I didn't think that I would be the sort of person who could do that until I was encouraged to do that by someone else. And so I applied for and became deputy chief of the Constitutional and Administrative Law Division because I wanted the chance to be able to give that back to other young lawyers in the Attorney General's office. You know, it's a hard job. There's a lot of, you know, hard work that goes in for, you know, limited compensation. And one of the best things that comes out of that job is the training and attention that you get from some really talented lawyers. And so I wanted a chance to contribute that myself in the Attorney General's office. I've also studied research on what helps keep members of underserved communities in the profession or in any position. And I gather, and what the studies have shown is that mentoring and encouragement from other more senior people is one of the strongest correlates to keeping people in the profession. And I've read reports of the well-being committee that talk about how members of underrepresented communities feel how important that is in keeping them in the profession. And so I think that same concern for how important it is to have encouragement and respect and to be listened to carefully is something that would inform my treatment of everybody who comes before me on the bench, if you were to confirm me.
Speak more about that in terms of both attorney wellness, so women and attorneys of color, LGBTQ community members as attorneys in your courtroom, but also victims and defendants. What you believe you'll bring to the bench in terms of a courtroom reflective of the kinds of values you're talking about.
Thank you for asking about that. I would strive to bring the same respect and attentiveness to everyone who appears before me, to plaintiffs and defendants, to family members and to victims, that I would want my own children to be given if they were to appear in Superior Court. And I would, another area that would be very important to me is encouraging younger attorneys to take a more active role in court. I was very lucky to appear before a judge who strongly encouraged the younger, more junior person on the team to be given a speaking role. And judges have done that through creative methods, like allowing a witness to be split between two lawyers. So I would strongly support using creative ways to help diversify the bar and give experience to other attorneys. And I would also try to be mindful all the time to maintain a tone of civility and respectfulness, because I think civility from the bar breeds civility in the rest of society.
I'm curious about so we didn't get to talk about this one either, but you talk about the disparities in resources, so economics, the impact of economics. I think what I'm reading is you're talking about it in relation to civil side, the economic.
Sorry, could you say that again?
I know, I wish they were quieter out there. In your application, you're talking about economic disparities and how it affects justice. And I think you're talking about on the civil side here. Am I correct? Is that what you're
Yes,
referring to?
when people have to hire their own counsel.
And can't afford, right, and so there's a built-in disparity. So I'd like to hear more about your thoughts around what solutions exist. And also it does look like you've done some work around encouraging more pro bono participation. So I'd just like to hear you talk about that, what your experience has been and what your thoughts are around solutions and what the impact of those economic disparities are on our in the how it plays out in our courts and who maybe doesn't seek justice because they can't afford justice.
Thank you very much for raising that. That's a subject that I have given a lot of thought to over my 29 years in practice. When I was in private practice, it was an issue that was on my mind all the time because except in certain defined areas of the law where there's fee shifting, like discrimination law and medical malpractice, where there's contingency fee arrangements. Otherwise, my clients had to pay by the hour for my services. And I have a lot of really discouraging experience speaking with clients and having to counsel them about the real costs of litigation. And those costs are only increasing. I think that judges have an important role to play in helping litigants helping manage the flow of litigation and the costs of litigation to help make it more affordable for people. I think one way to
judges in terms about like expedience of what are you talking?
So there are a whole range of different creative ways that judges can do that. So a few years ago, the Superior Court adopted Rule 20, which allows for different ways of managing the flow of litigation. So for example, you can have an expedited bench trial, and you can have the judge act as a mediator. I have used it myself to sort of propose creative solutions to make litigation less expensive for my clients. So for example, I have proposed that a judge hear a whole portion of the case on the papers alone, because that's a more efficient and faster way of resolving maybe one portion of the case. I think also through active management of cases. Sometimes, for example, there is one judge I highly respect who manages in discovery disputes, which are, an unfortunate and can be a very time-consuming part of high stakes litigation. He handles it by having the parties just have a free phone call before they actually engage in all of the expense of motion practice. And he can often give some quick guidance. And with a little bit of guidance from a judge, the parties can often work things out on their own in a way that avoids a lot of the expense of motion practice. So that's just one example, but there are a lot of creative ways that judges can use to help streamline things and keep litigation expenses from running.
I appreciate that you have that insight, that motivation. How pervasive do you feel that this attitude is in the judiciary? Like, is this something that is of concern broadly, or there are some judges that you've experienced who do make an effort towards, making choices that help economically? But is that a consistent experience that you've had, or really the rare judge who is concerned about it?
Well, I can't speak for the judiciary overall, but I know that judges I've appeared before have been very receptive to ideas about how to make things more efficient, especially if both parties are coming with, a joint idea about how to proceed. I found judges have been very receptive and understanding.
No, I appreciate that. It's an area of concern, and it would be great to see progress around it. Sort of dovetailing from that, indirectly related, but not really, access to justice. And we had a little conversation about one element around accessible language, right? So which is only indirectly related in that, when you have a self-represented, which happens less in Superior Court, but across our courts, it's an issue. But still, I think is important, regardless of whether someone is represented or not, the accessibility of language in court proceedings, just in an interest of comprehension, participation. I think it remain, even if there is an attorney present representing a defendant, I still think I personally think accessible language is an important thing in our courts. But I wanted to hear your thoughts around access to justice broadly, the areas that are of most concern to you, and then specifically around accessible language.
That's a really important topic, and I share your concern about accessible language. It is often hard for us lawyers to speak in plain English, but I think it's really essential. And it's particularly important for judges when they have a whole range of people in front of them who come from all different backgrounds and bring all sorts of different things to the table, that they speak in simple terms and that they explain themselves and they explain what's going on. I have had the opportunity to watch some wonderful judges speak with self-represented litigants in court, people for whom, this is the worst day of their life. And to have the judge explain very simply what it is the judge is concerned about, what information the judge needs, is something that makes a lot of difference in making people feel that they've been treated fairly by the justice system.
I appreciate that. I think there's been a lot of good progress around these issues, and as always, we can always do better, right? Continue. I feel like I could ask you questions all day long, but I will mostly leave it there. More as a personal comment. So I received a text while we were talking, well, earlier, not while we were talking, but it turns out your dad taught my husband comparative religion in his senior year of college. So it was just a little personal connection there. He's quite certain you won't remember him, but I just wanted to mention that little personal connection that I only just discovered today. So having said that, I'll close my questions there, but it really has been a pleasure getting to know you.
My pleasure as well.
Thank you.
Thank you.
I do say that I have no control of it and I can't answer why, but I'm sorry that the public can't see who was talking, and that was Counselor Jacobs. And I just wanted to recognize you because it isn't my choice, so I keep on trying. I want to thank you for all the time that you afforded me. It was such a pleasure. And you are now on the Hall of Fame for the Belgian waffle at the diner with Counselor Gans, God rest his soul, and Counselor Island, Counselor Hines, all of them. And it was such a pleasure. And it's important for me to meet with you because I'm voting for the whole person. I don't want to come in here on a Wednesday and look at papers and look at you. I know you. I feel like I know your family. And so with that, I have some questions. First of all, I'm concerned about disabilities, and I know we share that. I served on the Commission on Disabilities for 22 years. So I want judges to understand disabilities, and a lot of them don't. So tell me your experience.
I really appreciate your raising that topic because that is a topic very close to my heart. As I was discussing with Counselor Ianella, my own family has been very indebted to caring special education teachers who have really, we have such a wonderful program in Brookline. We have been so lucky to find them, and they really have changed our lives. So I really appreciate how important it is to have resources available to people, to meet people where they are so that they can access the full range of educational opportunities and the justice system that the rest of us can take for granted. I have also been fortunate to represent clients who have been coping with disabilities. I had a real education from a doctor that I represented before the Board of Registration in Medicine, who was diagnosed with behavioral disabilities that were the source of the behaviors for which he was appearing before the Board of Registration in Medicine. And I really learned from him, and I took what I learned and I educated the board about how his disability affected his behavior, but also about the treatment that he was getting and how much a difference, and I saw myself in him, how much difference that treatment made in his overcoming some of the behaviors that had been causing problems in his own life. So it's a very important topic.
Right. Many of us will never forget the tragedy of those kindergarten children that were shot to death, who should have been graduating from high school this year. And it's heartbreaking. And you have been involved against a national gun rights group. And tell us about that. Now, it is under advisement, and I don't know, since you gave us your questionnaire, if that has come to conclusion. So tell us about that case.
Thank you for giving me a chance to tell you about that. That is a case challenging our ban on assault weapons and large capacity magazines in Massachusetts. It's a law that's been on our books for 25 years. It was upheld by the Federal First Circuit Court of Appeals about 4 years ago. But in 2022, when the Supreme Court issued the Bruin decision, it changed the law on the Second Amendment, or at least it gave us a new standard under the Second Amendment. And so a national gun rights group brought a case in federal court in Massachusetts. And I feel deeply privileged that Tim Casey asked me to represent the Commonwealth in that case. I have tried to bring to that case what I've learned as a trial lawyer about the importance of teaching the court about all of the facts. And so we put in an incredibly rich record. We have nearly a dozen expert witnesses testifying on matters ranging from the history of gun laws, the history of gun violence, gun technology. We put in information about the science of the wounds caused by assault weapons. And we have been very lucky that last December, the federal district court issued a decision in our favor. It's a preliminary injunction motion, so we're still at the first phase of the case, but it was a very strong decision, strongly upholding our assault weapons and large capacity magazine ban. The case is currently on appeal to the Federal First Circuit, where it's fully briefed and it's scheduled to be argued in October.
As you know, the governor just recently, and I was honored to be invited to her signing of a sweeping act against guns. So we're very proud of the governor to take that action. So we talked about pro bono. That's very important to me because that shows compassion to care about people who can't afford a lawyer or whatever. So I want you to tell us about that particular case where there was an inmate and he wasn't getting the dental care that he should. And I go out to prisons and I meet with inmates. And I can tell you, there's some that are really actually dying. Some they're not getting, in some of the prisons, not all of them, but are not getting the medical attention that they deserve, that we can get. So, we forget about dental. So tell us about that case.
I'm so glad you asked that question about dental care. That case came to me. He had the gentleman I represented, Mr. Sullivan, represented himself in court, and he had actually achieved an early victory in the case in the appeals court, and it was sent back to the Superior Court for trial. And at that point, Judge Janet Sanders called over to Todd and Weld and told us about the case and asked if we were interested. And I volunteered to take on the representation. And it was one of the, most significant experiences of my life. I thought we could negotiate a settlement, but instead we really had to try the case all the way to the end. So what was the case about? It was about actually getting regular preventive dental care. So, you say dental cleanings, like why is that so important? Well, what I learned from our expert witnesses that we put on the stand is that it's that preventive care that actually identifies problems before they become so severe that the person has to lose the whole tooth or all of their teeth. So I spoke with incarcerated men who one gentleman had lost all of his teeth in a way that regular preventive care could have helped identify and treat before he lost his teeth. And it was a really amazing experience. I tried the case alone, but what really won the case were the inmates who came and testified compellingly about their own experiences. And we were very fortunate to get a judgment in favor of my client, entitling him to preventive dental care for the rest of his life sentence.
Well, I think that is, I think it's important to show your compassion, and that's what it is. And I don't vote for anyone if they don't have compassion. You have to have compassion and empathy before the people that come before you in court. And that's the most important quality. Now, I have talked to a lot of people and they say you're excellent in writing. And we know that you need to write in the Superior Court. So can you tell us about your writings, your publication before you send? Tell us about that.
I thank you. I'm really impressed that you found that. That was during a time when I was doing a lot of sort of complex business litigation involving complicated LLC businesses. And we encountered an issue with attorney-client privilege within the LLC structure. So you have different directors, our case involved 4 directors of an LLC. Who is the client and who is the counsel in that situation? What if it's in-house counsel employed by the company? So the rules on that were fast developing at the time that I was litigating that case. And it's an incredibly important thing to know about when you're actually, in the trenches representing business clients, because when you're the lawyer, you expect that when you speak to your client, everything will be cloaked by the attorney-client privilege. But that's not actually the case. There are many aspects of those communications that are not protected by attorney-client privilege. So I wrote that article to try to give a how-to guide, really, to the lawyers in the field who are out there speaking with their business clients to help them understand what was and was not covered by the attorney-client privilege.
In my 25 years, I have never seen an answer to a question as you have put. And you're asked what you believe, what 4 attributes or qualities you believe should be given the greatest weight to evaluating judicial candidates, and how do you assess yourself pursuant to these attributes? And you said, I believe the 4 most important attributes in a judge are impartiality, a respectful demeanor, clarity of expression, and experience. And I like what you said about impartiality, because I see there's a lack of that in some of the judges today. And we don't have a crystal ball as counselors. So we don't know what someone's going to do 10, 20 years from now. And you can be disappointed in that person. And what you said was, by impartiality, I mean not only the absence of actual bias, but also the active effort of engaging with each case on its own merits and putting aside one's own attitudes and preconceptions. And that says it all. That's very meaningful. And a respectful demeanor, because I'm hearing that some judges are not respectful. And you know what I'm finding? A lot of it is aimed at women attorneys. So that is very disturbing to me. So in my little way, I try, but I don't have that much ability to address that or even remove some of these judges that have had so many complaints. So having said that, I just think this is great, what you said. In legal experience, you've had 28 years, and I think that's important, and you've really seen it all. You've had civil and criminal, but what I see in you, that you are representing people. And that to me is so important. And going back to the writings, you gave us a sample. Do you want to talk about that sample that you gave us?
Yes, thank you for letting me talk about that. That was a case I was very excited about. It involved operators of sober homes who were actually misusing the disability discrimination laws to argue that they should not have to put automatic sprinklers in sober homes, which are homes where people come when they're recovering to live together and recover from addiction together. And so it was really, I felt, an abuse of the very important anti-discrimination laws to use those laws to give people recovering from addiction actually less fire protection than people who did not have that disability. And so on behalf of the Commonwealth, I submitted an amicus brief to the Federal First Circuit Court of Appeal, in which I made an effort to explain to the court in using real science and data how important our fire safety laws are and how they genuinely save lives, and especially in group living facilities like sober homes. And so I hope that with that court's decision, we are making sober homes safer for people recovering from addiction.
Well, I have to tell you another instance in my 25 years. The question that's asked in all the questionnaires to the nominees about the Superior Court and what the importance of the Superior Court. And you said the jurors. I have never, ever seen that before. And you know what? We're seeing that in a trial that has gone nationwide right now in Massachusetts. And we've seen now how important the jury is, haven't we? We really have. And so that came right out at me and I'm saying, wow, is this time appropriate? These jurors are coming out and they're saying things that we didn't know that would have affected the outcome of that trial. And it is so important, the jurors, and how I've never seen that in 25 years. So you get the award for being the first. But I can't tell you, meeting with you, how much that meant to me, because I found out so much about you, your upbringing and your family. And it was just outstanding all the time that you gave me. So, I don't want to, I could go into so many other things that we talked about, and I present it here when I meet with someone because I want to share what I've learned about you. And I think I have done that. And I do want to, I'd be remiss if I didn't thank Councilor Jacobs, because it would be very lonely alone up here. And that she stayed with us to the end of the hearing in respect to you. Now, I have letters for you. And one of them was former Justice Neal. And I have to tell you, I know him. He's from my hometown, Watertown, and he made us proud. I wasn't here in 1992. Councilor Ianello voted for him, but outstanding. And he was on the Superior Court, and he said, "You're a brilliant lawyer, in particular, a brilliant writer," which is so important on the Superior Court. But he talked about a case that he saw that really showed how you are so understanding about the rule of law and understanding of individual rights. And he said that he has no doubt that as a member of the Superior Court, she would make well thought out decisions and issue written orders, making valuable contributions to Massachusetts law. And he talked about your ability to write. And he also said that your leadership of the officer's team defending a lawsuit rewarding environmental conditions at the Springfield Courthouse. So you've covered it all, whether it's climate, whether it's people's rights or whatever. And he said you have a unusual broad depth of civil experience that I have seen her draw on. Julie came to the Attorney General's office, already a seasoned lawyer who had handled cases across a wide array of subject areas. In private practice, handled a considerable number of matters in probate and family court, which is a valuable experience for the Attorney General's cases. And, he says that you have both the confidence and open-minded humility to be an excellent judge. So, I don't want to take everybody's time. I wish I could read every word of these, but you're welcome to see these letters, and they're wonderful. And he said, in sum, I support Julie Green's nomination to serve in the Superior Court without reservation. And knowing this judge and knowing him as a person in my community, he's just the most kindest, compassionate, outstanding person I know. So I had to put that. It is a personal note. We got a letter from Lauren Bernard, and which said, just about the same thing, and of promoting equity and opportunity by providing much needed after-school opportunities. And I don't want to let that go, because we talked about that, and I want you to mention your after-school activities and involving those from low-income families who make up a significant portion of the Ridley school community. So I don't want to close this hearing without you talking about that. So you've covered it all, and these people, to take the time to write these letters means a lot. And so I think that is that the conclusion of my letters, I think. Not sure. Okay. I have one more for the Supreme Judicial Court from Judge Elizabeth Dua. And she says that you have the confidence and open-minded humility to be an excellent judge. And she talks about that you have had several occasions while you tasked the most in handling oral arguments in exceptionally difficult cases. She's certain that as a judge, you would likewise embody an unwavering commitment and excellence while also maintaining the humility necessary to see all sides of a dispute. I support Julie Green's nomination to serve on the Superior Court without reservation. So, I can't add any more to what they have said, but I want to give you that opportunity. Talk about that after school program that you've been involved in.
I would love to talk about that program. In fact, my dear friend, the executive director of the program, Lauren Bernard, is here, tireless community advocate. The program is called DASEP, a daily after-school enrichment program, and it's a program that provides after-school educational opportunities for kids. And what's so important about it is that it provides these opportunities in an affordable way, right, based at our local public school. It serves 300 kids per semester with, dozens of classes, things that families would have a hard time affording in other circumstances, like private music lessons and sports and homework help. And I think the thing about DASEP that has been most rewarding is the way that DASEP really makes an effort to serve the entire community. We have a significant portion of low-income families in our local public school community, and DASEP has been proud to be able to to offer room for every student who wants to attend, with tuition assistance to everybody who needs it. There are no other after-school programs that I know of that are able to offer that. And so I have worked with DASEP for about 10 years, helping with things like writing grant applications and loan applications to help fund that very generous tuition assistance program. And I'm so proud of what DASEP does.
Right. Thank you. I mean, we could go on and on about all the things you've been involved in, but I think that you have put it forward today. And I thank everyone for coming. You've got great support here and you had great witnesses. And again, I thank you for all the time you afforded me. So at the next public assembly that the Lieutenant Governor serves at, I will present your name, and hopefully it'll be next Wednesday. and the council will vote on your appointment. I thank the governor for this because this is an example of not insiders. This is a person that's qualified, and she did it the old-fashioned way with her qualifications. And can't tell you about the last 8 years. Let it go. I don't want to discuss it. We did have good people, but the political people outweighed the others. This is not going to happen. And with this administration, whatever she can do to have the best people come forward. I thank you for applying. And I look forward to voting next week and presenting your name. And I thank you all for coming. This is a great attendance, really. So I adjourn. Thank you.
Thank you, councilors.